Thank you, Chairman, and thanks for the opportunity to share my views in this great forum. The first question, is competition a driver of environmental protection? My answer would be yes, but yes with two qualifications. Yes, dynamic competition can be a driver of environmental protection when consumers are prepared to pay a premium for environmental friendly products. This induces competition to capture these premiums. And also if there is a demand for environmental friendly products, firms may invest in R&D for product and process innovations in a green direction. My first qualification is that competition is also one of the causes of environmental damage to start with. Many environmental damage problems find their roots in the tragedy of the commons problems, which leads to an overuse of common resources. The use of air, soil, and water as inputs in production processes is not properly accounted for in cost and prices. This creates negative external effects, implying that prices are too low and output is too high from a social welfare perspective. And since competition policy typically brings prices down and output up, in this sense, competition is at odds with environmental protection, you could say. That is the first qualification. The second qualification is that dynamic competition is not always a driver of environmental protection. And this is related to your second question. There are circumstances in which competition stands in the way and cooperation agreements between competitors are needed to reduce environmental damage. What are these circumstances? Christina just mentioned a couple of them. First, cooperation may be needed to avoid first mover disadvantages. If a firm is the first and the only one to introduce an environmental friendly but expensive product, and that product competes with cheaper environmental unfriendly products, then as long as there are cheaper alternatives available, consumers may switch too much to cheaper alternatives. And cooperation may then be needed to limit the alternatives to which consumers can switch. The second set of circumstances is that cooperation may be needed to prevent free riding by consumers on other consumers, more behavioral. Even if consumers care about environmental protection and have a sufficiently high willingness to pay for more expensive environmental friendly products, free riding behavior can prompt those consumers to switch to cheaper products. The attitude of let others contribute and me enjoy environmental protection. And in addition, consumers may only have a high willingness to pay for environmental friendly products if they feel assured that others also contribute to the reduction of environmental damage. And cooperation can help limiting this type of free riding behavior. And then the third and final set, production of environmental friendly products may involve fixed costs. And these can be, for example, the fixed cost of setting up a new system or the R&D to develop a new production process. The volume of an individual firm may be too small to cover these fixed costs. And in that case, the combination of volumes of more firms is needed to achieve environmentally friendly production. Now I come to the last question, which is why a different approach to competition enforcement might be required in specific circumstances to deal with environmental protection. Well, in circumstances where cooperation between competitors is needed to reduce environmental damage, competition law enforcement should, in my view, be facilitating cooperation that improves social welfare. Arguably, there are other and better instruments available than competition law to reduce environmental damage, but as long as the need is as pressing as it is all hands on deck, including competition law hands. At the very least, to take away the possibility that firms use competition law as an excuse not to come forward with initiatives. Is the current approach to competition enforcement facilitating these joint private initiatives? In the European Union, in my view, this is currently not in all circumstances the case. Yes, there is the possibility of an exemption to the cartel prohibition, which allows cooperation between competitors under strict conditions. And yes, environmental benefits seem to qualify as benefits that can offset negative effects of cooperation for consumers. And these benefits are rightfully interpreted in a broad way and include price and non-price effects. There may be some measurement issues which the chairman put forward, but in principle, at least in my view, on the current EU competition law enforcement, these benefits qualify as benefits for exemption. What is not facilitating, in my view, and what may need, why a different approach might be needed, at least in EU-related competition enforcement, is in two areas. First, the full compensation for consumers condition, which may be too strict. One of the conditions in EU law for an exemption of the cartel prohibition is that the same consumers that face the negative effects of the restriction of competition should be fully compensated for these negative effects by the benefits created by the restriction. But the point is that in the case of cooperation to reduce environmental damage, the benefits are typically larger than just for consumers. The benefits also go to others. In fact, in many cases, they concern society at large. And that is the reason being that negative external effects are being reduced. And this can lead to a situation where under the full compensation for consumer condition, cooperation is not exempted because the benefits for consumers are too small, although it is beneficial for a larger group or for society as a whole. And because the very essence of agreements to reduce negative external effects are these broader benefits, the full compensation condition, in my view, is not appropriate in this context. I'm not a lawyer, but it is my understanding that under EU competition law, the full compensation condition is not a matter of law, but a matter of policy. And then the second area in which a different approach in EU competition enforcement, in my view, might be needed is related. The current focus is exclusively on the welfare of end consumers, but there are other interest groups. In the case of environmental damage agreements, in a way, the end consumers are the polluters. And there is no justification, in my view, to exclusively focus on them and not include other citizens. So it's amongst others for these reasons that the Dutch Competition Authority has proposed, under specific conditions, to take within market benefits as well as out of market benefits into account in the assessment of whether or not the benefits of an environmental damage agreement outweigh the negative effects of the restriction of competition and deserve exemption from the cartel prohibition. And that concludes my initial remarks. Thank you very much.